Well, welcome to our first oral argument. Very exciting for us. Hope it is for you too. We have three cases on the docket. We'll take the first one, 1524-0087, consolidated with 00090, NRA Google LLC. We'll take that argument. At the end of that argument, we'll take a 10 or 15-minute break. Judge Ferris is not sitting in this case, so we're glad to have former Chief Justice Woody Jones sitting with us. We'll take a break, and then Judge Ferris will be joining us for the second and third case. So, if all parties are ready, we'll hear from Relator, Ms. Hargrove.
May it please the court, good morning. The trial courts below clearly abused their discretion when they denied Google a right to depose the plaintiff on any topics whatsoever. This is a clear abuse of discretion for two reasons. First, Rule 199 allows parties a broad right to depose any person or entity, and the state of Texas is undisputedly an entity under this rule. Second, the topics at issue here seek relevant information that go to the heart of the case. Google is trying to depose the plaintiff. It asks the plaintiff about basic issues such as its contentions as plaintiff and the facts underlying those contentions. The trial courts chose to deny Google a right to depose the plaintiff about any of these matters. Instead, they accepted the state at its word when it argued that the depositions were improper because they were unduly burdensome and called for privileged information. But Texas law, established Texas law, requires the parties seeking to avoid discovery to present evidence in support of its objections. The state did not do that.
Is there anything in the deposition topics that's not in the mandatory disclosures that should have been disclosed at the outset? I mean, it looks like it's name and address, legal theories and contentions, calculating damages. Looks like the vast majority of what you want to depose them on is a matter of disclosure. Am I right about that?
I do think a lot of it should have been disclosed in the initial disclosures. Those are not in the record. The state has not presented the evidence that it has provided any of this information to us in written discovery. But it's important to note that depositions are unique. Depositions are a procedural discovery device that are available to all litigants and that allow us to get information that you simply cannot get through written discovery. In particular, and important here is the ability to ask follow-up and clarifying questions on what is, that is just irreplaceable.
Did you move to compel the disclosures?
To my knowledge, we did not move to compel the disclosures, Your Honor, but I don't believe that would have cured the harm to Google in a case like this because of the paramount importance of depositions. It's also important to note, Your Honor, that depositions are of critical importance to the discovery process, of course, as we all know, but it's also a method of getting trial testimony. We have the right to present the testimony of the plaintiff at trial. And so by being deprived of our ability to secure this basic discovery right, as well as this trial testimony, there is irreparable harm here.
Ms. Hargrove, if we, I know this is getting down the road, but let's assume for a second we decide that Google was entitled to a deposition. What's the remedy? Does this court have to go topic by topic in both cases to decide whether the state met its burden of proving those objections? Because there's some objections that require proof, and there's some objections like relevance that do not. Do we have to go through each of those, or if we decide there's a right to a deposition, do we remand for that determination?
Your Honor, I believe the court can do either because of the posture that this case is in. The only way that the trial court's orders could have possibly been upheld is if each and every single topic in both deposition notices were improper for some reason. And so I think that gives the court the flexibility here to either choose to say, A deposition is appropriate, and on remand, the parties are directed to meet and confer, as they should have done from the beginning. The trial court can resolve individual issues on the topics, but I think it's also within the court's authority and power to decide that particular topics are proper, kind of on their face. And I think that doing so in this case would likely be helpful and the practical and most efficient way of addressing this dispute. But I would say that because there was no meet and confer process here, I think it would be improper to, for example, strike a topic down altogether as overbroad when we didn't even have an opportunity to work with the state. We were deprived of that opportunity.
I assume that your position would be that if even one topic is proper, that the trial court's order was an abuse of discretion.
That's correct, Your Honor. Because of the way, this was just an up-down ruling, that we just don't get a deposition on any topics at all, no matter what.
And so you would concede the state is not a state agency. State agency's got to be an agency of the state, and the state can't be an agent of the state because it is the state, right?
Well, what I would say, Your Honor, is that if you look at the text of Rule 199, when it applies to governmental agencies, the only way to read that is it includes a situation like this one where you have a governmental agency suing on behalf of the state of Texas.
So the problem, clearly the Attorney General represents the state and all its agencies in court and litigation like this. And so clearly they're the attorney. I would be extremely troubled if people could use Rule 199-2 to depose their opposing attorneys. And I assume you would be too. And so how can we do that here? I understand since they represent the state, they're going to have to be the ones who say what our contentions are, what our calculation of damages is, but hence my question on disclosure. Normally that's handled by disclosure. Normally when you depose an entity, they prop up somebody from the company who, or an investigator, or whatever their expert witness is going to be. And I bet the Attorney General could do all of that. And I will intend to quiz them about when they're planning to do that, because for crying out loud, there's nothing that's more frustrating to trial judges than, you know, here's our mandatory disclosure, and the answer is all, we object, and we'll tell you later, and we'll supplement, and they never do, and then you end up in big fights about what comes in trial. But I'm just, who would you prop up? Because the Attorney General is not the state. It's just the attorney for the state. So who's going to show up? Going to have the governor show up, or the governor's chief of staff, or somebody from the legislature? I mean, the Texas Supreme Court has expressly said that the Attorney General doesn't speak for the legislature. So I'm troubled by, I don't disagree, the state is an entity, but it's not like other entities. So how do we deal with that problem?
I think, Your Honor, it's important to remember what the topics in play here are. Most of them go to what are your contentions and what are the facts. And these are not privileged matters. I agree it would be improper for us to quiz opposing counsel on the details of their legal theories, and that's not what we're trying to do. But the AG acts in a number of different capacities, and I would suggest that one of the capacities here is essentially as plaintiff. And that's all we're asking to do is depose the plaintiff. But also because this is a corporate representative deposition, there are protections available through that procedure. The Attorney General can designate whoever it wants to testify. It can be someone who has never touched this lawsuit.
Or whoever they're going to call at trial. It could be that.
Or
person.
whoever they're going to call at trial. Exactly, Your Honor. Yes. And I think we have the right as the defendant to ask someone some questions about this lawsuit. We just do, and to have that testimony at trial as well. So I think the corporate representative procedure itself provides some protections, and I think as well, the Texas Rules of Civil Procedure as a whole provide those protections because they they give you a way of invoking privilege and protecting for privilege as the questions develop in the deposition.
Do you know who at the state receives citizen complaints about alleged violations? Is it the AG's office or somebody else?
Your Honor, it is the Consumer Protection Division of the Attorney General's office, and we would suggest that that is an example of a capacity the Attorney General serves in that is not just legal counsel in this specific lawsuit. And we, in fact, have offered to depose that agency, and they're objecting to that as well. We haven't been allowed any depositions. And so we really are in a position where we're defending a case. We haven't been allowed a single deposition, and the other side has had something like 130 to 150 hours of depositions. And so it's essentially a unilateral discovery situation, and the logical extension of the state's arguments here are that anytime the AG brings suit on behalf of the state of Texas, the other side doesn't get basic discovery. And that's a pretty big slippery slope that we're looking at, if that's true.
On the other hand, I understand there's some isolated trial courts that have ordered yes or no about the state being deposed. But I didn't see, maybe I missed it, either side citing a case where this has ever occurred. So you would be the first if we have to write on it, and we have to explain why. And if this is such a, people have seemed to been able to live without deposing the Attorney General as a corporate representative. For some of the reasons I described, they're your opposing counsel. And the last thing, I mean, I'm also been around for a while in this game. I've never seen anybody allow depositions of the opposing counsel. We just cannot get into that because it's, everybody will do it. The state has to join many times as a party, or at least intervene whenever the constitutionality of a statute. People are claiming statutes are unconstitutional all the time. We can't depose the Attorney General in all of those cases. They'll have to have a new division. They'll have open records, consumer protection, and testifying, attorneys. How is this gonna work?
So I would take issue a little bit with the idea that this has never happened before, because I'll say we put examples in the record for the last 20 years or so. At least my law firm has deposed representatives of the Attorney General over and over again in cases where the state is a party, and there are examples of this in the record.
Based on trial court's orders, or based on, was it
Often by
challenged?
agreement of the Attorney General, but we do have at least one example in there of the trial court ordering that to happen.
But there's
The
no,
Meta
but
case
there's
is
no
another.
opinion giving us an analysis to follow.
That is correct within Texas, because frankly, I think until recently, the AG didn't start raising this objection, and so it just really never came up. We have included some federal authority in our briefing, Your Honor, where courts have really wrestled with this issue. There's I believe it's the SEC v. Merkin case that actually looks to Judge Scheinlin, the discovery expert on the federal rules, and then kind of really does a deep dive in the context of an SEC enforcement action about how this should work, and essentially concludes that because this is a corporate representative procedure, there are protections in that. And any time you're deposing a corporate representative, for example, attorneys are getting them ready. I mean, that happens any time.
I don't doubt that, whenever somebody responds to a deposition on the contentions, they're doing what their attorney told them to say.
Yes, and I think I would suggest looking at those cases can be helpful because of sort of those fundamental guidelines that can guide us. But the idea that the alternative is that the state can sue anyone it wants in an enforcement action and not have to answer fundamental questions and not have to testify gives an enormous amount of unchecked power to the state, and essentially gives the state a pass on the Texas rules of civil procedure. If you look at the text of Rule 199.1A, it allows the deposition of any person or entity, and that the state is an entity. The AG is trying to focus on very hyper-technical reading of the procedures in 199.2 and a way of avoiding a discovery right that is just in the plain language and structure of the rules.
I feel like I'm missing something, because you're not, I mean, you alternatively asked for the Attorney General's office deposition, but you're asking for the state, who is the plaintiff's deposition. So you're not directly, at least asking for the state's attorney. You're asking for the state's deposition, and they can designate whoever they want.
That's exactly right,
They
Judge.
could designate someone from an agency, they could designate a non-attorney, whoever it is. Am I missing something, or there's so much briefing on what 199.2 means? Isn't 199.1 dispositive of whether a deposition occurs or not?
Absolutely, Judge.
Okay. And then is 199.2 the term organization and entity? Why are they different? Why are those, do those mean the same thing? Are they different?
Let me just say for the clerk, since one of the nice things about being Chief Justice, I'm going to unilaterally give both sides 5 extra minutes since I talk so much and took up so much of your time. So I'm going to give my colleagues a chance to ask a few questions and you to spend some of the time of what you plan to say before I interrupt you.
Thank you, Your Honor. In response to your question, Justice Field, yes, Rule 199.1A is dispositive because it governs who may be deposed. 199.2B governs the procedure for bringing that deposition about. You're right, it does use the term organization rather than entity. Neither the rule nor the comments explain why. My guess is that it makes sense because in that context, you're explaining that the procedure is a little different for an organizational witness as compared to an individual witness, and that may be why that language was employed the way it is. But if you look to dictionary definitions, for example, of the terms entity and organization, they match. They're very much coextensive, and I think the use of the terminology other organization at the end of the list of possible organizations in 199.2B shows an intent to expand the scope of that provision to match 199.1A. And also, if you look at the rules regarding essentially enforcing the right to a deposition in 215.1, that rule goes back to the entity language. It says if a party or other deponent, which is a corporation or other entity, fails to make a designation under Rules 199.2B1, the discovering party may move for an order compelling a deposition. So I think when you wrap all of these rules together in context, you see that the intent was to allow you to take the deposition of any entity, and certainly to interpret the rules in such a way that you cannot depose a party, so it simply can't be what the drafters of the rules of civil procedure intended.
199.2 uses the phrase other organization, but it is patterned after Federal Rule 30B6, I believe. 30B6 says other entity. Do you know or have any idea why the state uses other organization, whereas the federal rule says other entity?
I do not know the answer to that, but I think, again, within the Texas rule, you look at the rule that describes who may be deposed for your answer to the question of who may be deposed, and it's as simple as that. And I think that, in particular, if you look at the use of the word in 199.1A, the fact that they use the word any to describe person or entity that is subject to deposition, that's extremely important. That's a broadening term. Any has been interpreted by the Texas Supreme Court to mean every. And so I think if you look to 199.1A, you see that the idea is sort of no matter what form you may take, you're subject to deposition, especially if you're a party. And also, Your Honor, we do have a number of federal cases cited in our briefing from interpreting 30B6. I haven't seen the answer to your specific question in those cases, but they do apply 30B6 to allow the deposition of the United States. The last point I'd like to make before I sit down, and I thank you for the extra time, is just a reference to the NRA USAA case out of the Texas Supreme Court a couple of years ago. I think that case is very on point here. It addresses a situation like this one where you have a party to a lawsuit who's claiming that they don't themselves have a whole lot of personal knowledge, claiming that therefore it would be very burdensome to have to present a witness for deposition. And the Texas Supreme Court went through all of those arguments and rejected them in the context of a corporate representative deposition and said, you need to educate yourself. You know, the parties generally have the right to depose each other. It would be, quote, highly unusual not to allow the deposition of the party, the other party in a lawsuit. And so I would recommend that case to the court as a little bit of a roadmap here.
In that case, the Supreme Court specifically rejected the idea that you have to do written discovery first.
That's correct, yes. The court confirmed that parties have the right to elect what type of discovery procedure that they want to use.
But this is an unusual case because in most corporations or other entities, you don't have a separation of powers. I mean, the Attorney General cannot bind the legislature or the governor or vice versa. And so we have a bit of an organizational problem. Who represents the state when the state is actually three separate branches of government? That's what troubles me. Is there any other analogous situation you can think of? You can think about it for a while, but I'm just...
Yes, it is unusual. I mean, I would suggest that what the statute says is that the state of Texas appears by and through the Attorney General. And so I think in that sense, the Attorney General is not just acting as outside counsel. It's acting as the party in that sense. It's representing the state. That's what the legislature said should happen. The state has made decisions about what claims to bring. The state will make decisions about what motions to file, about what positions to take at trial, what testimony to put on at trial. We're allowed to ask about all of those things.
Thank you, Ms. Hargrove.
Thank you.
We're ready to hear from respondent or appellee? I don't remember.
No party interest.
Okay, thank you. Mr. Cole?
Thank you, Chief Justice Brister, and may it please the court. The two mandamus petitions before you this morning present, as I see it, two overarching issues. The first is whether the state, qua state, is required under the rules of civil procedure to sit for a corporate representative deposition. The second is whether the Office of the Attorney General, as you said, opposing counsel in this case, is required to sit for such a deposition. Now, we would submit to your honors that the answer on both scores is no, and that neither trial court on these separate records abused its discretion in so holding. And I want to highlight a point that Chief Justice Brister made at some point during the argument last time. And I think the best case for Google here in this posture is the following. They cite some cases on one side that said maybe you can get a deposition of the opposing party's lawyer. They cited District of Nebraska, cited District of Ohio, District of Utah. We have some cases on our side going one way. Well, if that's the case, if there's cases on one side, cases on the other side, definitionally that can't be an abuse of discretion warranting the writ of mandamus in both cases. And so I think the easy way here is to look at that. I mean, that's not an abuse of discretion. But before we dive into the OAG issue, I do want to start for a moment with the state as such. And so our position, of course, is that the state as a sovereign entity is not required to sit for a corporate representative deposition. And I think the interplay between 199.1 and 199.2 are relevant here. So 199.1 really talks about the how of a deposition. If you look at the statute, it's talking about the methods for a deposition. It says
199.1?
199.1, yes.
I thought 199.1 talked about who.
No, that's 199.2. So if you look at 199.1, it says oral examination, alternative methods of conducting or recording. It's talking about subsection A says generally. It's stating a general rule a party may take the testimony of any person or entity by deposition on oral examination before any officer. B talks about depositions by telephone or other electronic means. C talks about non-stenographic recording. It's talking about the how. How do you do this deposition? Now,
You just read the provision that says you can take the deposition of any person or entity. I mean, isn't that the key language for us in this decision?
I don't think so, Your Honor. I think it's 199.2, and here's why. So I think it's talking about, A is talking about the typical way, the general way you take a deposition here is oral examination. Now, if you go to 199.2, it's talking about the identity of witnesses subject to a deposition, and it lists the witnesses. And among those, you find an individual or public or private corporation, partnership, or other organization, and you find the governmental agency. So
So you're saying 199.1 says any person or entity, and 199.2 then just says we didn't really mean any person or entity, we just mean the ones we're listing now.
no, I'm saying 199.1 sets forth a general rule that is later subject to exceptions. Of course, it doesn't mean literally any person. If I want to depose somebody about everything that's all privileged, obviously it doesn't count. You don't get to any deposition, but it's talking about the
I don't have it
witness.
in front of me right now, but doesn't 199.2 use, isn't a list a non-exclusive list?
I think the list doesn't include the state. Let me go to that list if I might. The list.
No, but first, is it exclusive or not exclusive?
Other organization captures other types of entities not listed. They list a couple of things that might well be the case, LLCs, nonprofits,
Does
of
it
course.
use the language only these entities, or does it use the language including these types of organizations?
No, it says including, but here's why that list doesn't include the state, if I might, Your Honor. So you see that it says individual, public or private corporation, partnership, association, governmental agency, or other organization, as a threshold matter. The state is not listed there. The governmental agencies are listed there. And now here's the category error I think Google's making here. The state is not, like all these other entities here, a unitary closed organization that in the way that Google is, for example. So the state is made up, as Chief Justice Brister has pointed out, of many independent, separate, many of which are constitutionally created offices. And here's where the rubber meets the road. So in the same way that Google can go to its marketing department or its R&D department or its accounting department and compel somebody to come sit for a deposition, we can't, as Chief Justice Brister said, go to the governor's office or the Railroad Commission, or how about in this case where they said they want a deposition about the cookie tracking technology in the General Land Office. The Land Commissioner is a separately elected constitutional officer. We have no means to compel the Land Commissioner's office to send us somebody for a deposition. In the same way, we can't go across the hall to the Chief Justice and say, Google thinks that maybe the judiciary is tracking the biometric information of persons.
We are another organization.
I'm sorry?
We are another organization.
The state is not another organization because the common thread between all of these other organizations is that they're a unitary closed entity with a principal or head that can compel actions. Again, the Office of the Attorney General can't compel the judiciary to send a representative here.
I guess my question is, can somebody, if the 15th Court is sued for some reason, we already have been sued for being unconstitutional once, and the question is, can we be noticed just right out of the gate? Send us somebody from a deposition.
If you're a party to the lawsuit?
Yep, somebody
Well-
sues us for discrimination or whatever else.
Well, if you're a party to the lawsuit, that's quite different. But this case is, if their rule then, if that's where we want to take it, their rule then is that anytime the state is a plaintiff, any agency in the state is subject to a deposition. That's not the rule. There's no case that says that, and that's important.
But isn't
Certainly.
that different what you just said? I mean, we're not saying any state agency can be forced to take a deposition. We're saying you state are the plaintiff, we've noticed your deposition as an entity, and now you as an entity can decide who testifies on those various subjects. I feel like we come to that part of the road and then they veer over here to other issues. What's the answer to that?
So I think not, Justice Field, because of this. We can't compel an independent constitutional agency to send somebody to us to go sit for a deposition. They may not even be able to talk to us about certain internal procedures separately when they're not represented. So there's no way to compel these independently created agencies of the state to come sit for a deposition just because the opposing party has noticed the state as such. I mean, the easy way to cut the Gordian knot here is just what Section 199.2 says. It's notice a governmental agency.
My guess is that if the state or the AG's office asked a state agency to designate a representative and the state agency said, no, we're not going to do it, I bet the trial judge could do something about that.
Well, I'm not sure because I don't know any rule that says that every single agency in the state is somehow before the court within its powers to compel them to attend. Now, to be sure, what I was just about to say is the way we resolve this is just what 199.2 says. You serve a third-party subpoena on the governmental agency. But I don't think the state itself, by merely being a plaintiff in the lawsuit, means that it's open season on every agency in the state for discovery. I mean, that's the upshot of what they're telling you is the rule. But unfortunately, there's no case that says that, which again is important in the mandamus context, where they don't have to just show that they're right as a de novo matter, which of course we would dispute, but it's an abuse of discretion.
But
And they
I
know
keep
that.
coming back to, they're talking about policy. And as a court, can we even decide policy as an intermediate appellate court? We're not the Supreme Court.
Sure.
As an intermediate appellate court, can we decide that any entity doesn't mean the state of Texas when page 10 of your brief says the state of Texas is an entity and the trial court pleadings that the state filed says we are a sovereign entity? Does any entity mean any entity, or does it mean something else? And if the answer is because of policy we can't get there, that's not a good answer for the court. So how do we get
Sure.
there?
No, it's not a pure policy matter. It's a matter of text. And again, I think perhaps you and I just have a disagreement on the import of Rule 199.2, which I think is critical. Again, I'll go back. 199.1 says it's setting a general principle about the methods of a deposition, oral examination. It says any party or entity, but that general rule is later qualified in 199.2, which lists the, quote, identity of witnesses that may be noticed. And again, the state does not appear there. And so I think it's actually 199.2 that controls here.
But let me ask you about the interaction between those two rules.
Yes, sir.
We've been instructed by the Supreme Court that the rules of civil procedure are to be liberally construed to allow the fullest discovery. Doesn't that mean that if there's any ambiguity, we have to construe the rules in favor of allowing more discovery rather than less discovery?
I certainly don't think that's what it means in the context of a mandamus petition where you're viewing the trial courts.
In general, forget about mandamus.
Well-
Is that what it means? That when we are construing the rules of civil procedure, if there is an ambiguity between two rules, we have to construe it liberally, which means if there's an ambiguity, we have to construe it to allow more discovery rather than less discovery.
I suppose if you get through all of the sort of textual analysis and structural analysis and all of these things, and all you're left with is this sort of presumption, then it's possible, but I don't think you're there, and I certainly don't think you're there, and I know you wanted to say just separate it out from the mandamus petition, but I really think that's a key thing here, because this is asking whether the trial courts abused their discretion, and so if you were convinced as a de novo matter that they're right, it's just not, that's not where, that doesn't entitle them to mandamus relief. It has to be a clear abuse of discretion, which is extraordinary, an extraordinary writ. And so I don't think you have to get to sort of, we've exhausted the text and the structure, and now we need to go to sort of this general background principle of the law. The text, I think, resolves this, again, with 199.2. They're listing the agencies. And again, the way to solve this, I think, is quite simple, is they serve a third-party subpoena on the governmental agency with which they want to ask information from. And they know this because they've been serving subpoenas on school districts and things of the like. And so that is, I think, the simple way to resolve this impasse here. That's what they need to do. But simply listing the state in a notice of deposition, there's no authority that I'm aware of that indicates that that's appropriate, because the state is just different in kind. It's not a corporation. It's not a closed unitary organization in the way that the other types of entities listed in 199.2A are. And so I think that's a significant difference.
So do you don't disagree that most, if not almost all of the topics they want, they're entitled to?
I'm sorry, most of all the...
all the topics they want to depose the state on, they're entitled to know what your contentions are. They're entitled to know how you're calculating damages. They're entitled to know how many people have complained about biometric data.
Well, let me go to a couple of those examples.
No, that's a yes or no. They're entitled to that. I mean,
They-
you're gonna have to concede that.
Oh,
Because if you don't, you're gonna show up at trial, and when you try to put on damages, what's the trial judge gonna say? You
Right.
didn't disclose it, you don't get any.
Yes, I'm happy to concede that they're entitled to those things because they have gotten those things, and they're just not entitled to them in this case through a deposition. And so let me explain why. Let's take, for example, the penalties issue. You'll note that the penalties issue has been subject to expert testimony. They've gotten expert depositions already on that in the Victoria case. They will in the Midland case. So there's expert testimony on that. Complaints we think are not relevant to the case, but let me set that aside for one moment. We've produced the complaints to them. They have those things, but they're separately not relevant to the case. And I think if I might, I'll fit this within my second bucket, which is that why they're not entitled to a deposition of the OAG itself. The topics are kind of overlapping in both cases, but they are entitled to some of those things, just not in this case through a deposition. So let me start in the Victoria case, if I might. First, at the threshold, the deposition of the OAG was noticed after the close of discovery. I mean, that by itself should be enough, I would think, to show that they're not entitled to this in a mandamus posture. But let me set that aside and move to the next point, and it's that, as you were saying, Chief Justice Brister, the OAG is the opposing counsel in this case. There is no real tradition or practice of having the opposing counsel sit for depositions about their contentions of the case. So you talk about contentions of the case. And if you look at their topics, they're asking for legal interpretations. They want to know what we think the statute means. And with respect, that's a proper subject of law and motion practice, not a fact deposition. And that's one of the key problems here. They're trying to sit a lawyer in the chair from the Office of the Attorney General and say, what do you think the statute means? What do you think, how do those facts apply to this law? And that's simply not appropriate to oppose the opposing party's lawyer about it, precisely because all of that is work product. It's privilege.
Let's talk about penalties.
Yes, Your Honor.
I assume, I feel fairly confident, that the number and nature of consumer complaints, for example, would be relevant to the issue of harm to the citizens of the state. And harm, then, would be one of the factors to be considered in determining a penalty.
So I would respectfully disagree on that. Harm is not a relevant consideration. Harm to a particular consumer is not a relevant consideration under any of these statutes. It's not in the text. And if you look at the DTPA statute, the factors included, harm's not in there. So the state doesn't need to even bring to you a consumer and say a consumer has been injured. Again, this is a civil enforcement action on behalf of the state. So I respectfully would disagree. That's not relevant here in the sense that it's not an element of the cause of action or a remedy that needs to be proved.
Okay, so you're saying that harm to the citizens, harm to the party is not relevant to the amount of penalty. Is that what you're saying?
It's not one of the factors that's listed in calculating penalties, yes. But on the penalties issue, I mean, number one, the penalties issue is going to be something that's subject, again, of expert testimony. There's expert reports that have produced expert discovery that's already taken place, including depositions in the Victoria case. And in the Midland case, there's also going to be expert discovery when it's time for that, including depositions of our expert. The simple point here is that they just don't get to depose the other side's lawyer about that, their contentions about it. Again, that's the province of expert testimony here.
As your opposing counsel said, I think it's the Consumer Protection Division that receives citizen complaints. Is that right?
Yeah, that comes into that.
And so they would not be acting as the state's lawyer in that situation, would they? They would be just receiving complaints.
Well, I'm not really sure what they're talking about. If we're talking about how we interpret the complaints, that would be a legal interpretation. I mean, the Office of the Attorney General, of course, is made up of lawyers and their support staff who are essentially their agents and so covered by the privilege. But if you're talking about...
It's a simple matter. A citizen calls and says,
Sure.
I have found out that Google is using my biometric data for da-da-da-da-da-da.
Yeah. I'm not saying that that's privilege, but I'm saying we've produced those things. We've produced citizen complaints to them. They have them. So
Now they're not allowed to take the deposition of a person because they already been produced.
I'm sorry?
They're not allowed to take the deposition because documents have been produced?
No, what I'm saying is that they wanted to depose a lawyer about how they interpreted those complaints. I don't understand the deposition topics to be suggesting they want a file clerk who received the call or something like that.
Isn't the easier argument on, I'm finally gonna throw you a softball here, isn't the easier argument on the OAG deposition just that they're a third party and they haven't subpoenaed them?
Well, sure, they haven't, well, they have issued they've noticed the deposition. That's also another argument. I'm happy to take that, but I think,
I mean, isn't
again.
that right? Aren't they a third, I mean, isn't that the core issue here, that the state's a party,
The-
an entity? The OAG represents that entity, but they're not a party to the law.
Sure, it would be as if we asked to depose the other side's law firm. Yes, I agree with you about
Right,
that.
you'd have
They-
to subpoena Scott Douglas. to
Sure,
appear.
sure, that's right. But I think one of the other relevant things here to consider is that the state doesn't have any percipient witnesses to their violations. I mean, so they say they want the underlying facts, but the underlying facts are housed in Google. So you asked earlier Chief Justice Brister about what's going to happen at trial, when are they going to get this information? Well, I don't want to speak for the trial lawyers that are going to try this or bind them to anything, but what I suspect is going to happen is that Google's witnesses are going to supply much of the information at trial, and then we're going to have expert testimony. So I don't think it's a surprise here that Google may be having, as I think they're saying, they sort of point to this asymmetry here that we've had to respond to more discovery. But of course, it's Google's conduct that's at issue. State's conduct's not at issue. So it's unsurprising that Google would
They
be.
know that they're using biometric data for commercial purposes without telling anybody.
Quite right, quite right. But it's not OAG, it's not the state, it's not, I mean, one of the deposition topics, just to pull it out here, the Victoria deposition topics, 11 through 14, they want information about the use of cookie tracking technology across 10 separate agencies, from river authorities to the General Land Office. I mean, first of all, their conduct is not relevant, and the only way it's relevant here, and let me spot them this, they want to say it's relevant to a selective prosecution claim. Well, the trouble is, in the Midland case, the state was granted summary judgment on that. So that's no longer at play. In the Victoria case, it was never even raised. So again, that's not relevant. It's just a sort of a fishing expedition.
You can raise that objection with the trial judge and say, the fact that if you're plaintiff suing the defendant for running a red light, you can't ask the defendant, tell us every red light you've run. Because
Sure.
if it's not this one, it doesn't matter.
Quite right, quite right. And that's also relevant because, again,
But you can raise that with the trial judge.
well, and the trial court, again, granted our
In toto, but not line by line, and that's one of their objections.
I'm sorry, can you rephrase that?
That's one of their objections. The trial judge just said you can't depose the state, period.
Well, so a couple things about that. First, the orders in this case aren't reasoned in the sense they didn't write out their analysis. So, of course, the court is looking to what's in the record. And you spoke earlier about, well, are we supposed to go through this topic by topic and determine? I don't think that's necessary or appropriate in a mandamus petition context. Again, we're looking at this through an abuse of discretion lens. And so we look to the record to see what's there. And it's in the record. These objections were raised in the motion to quash, the objections, the oppositions to the motion to compel, even on the record before the trial court. So the trial court had this stuff before them. And so...
But do you agree that if there's kind of two pieces of the analysis. If you decide the state has to sit for a deposition, then the second question is, are these topics, did the trial court correctly sustain the objections to every single topic? Isn't that correct? That's our review?
So let me tease that out into sort of two buckets, if I might. So there's the state as such. I mean, we're saying the state is not, under the rules, under sort of matter of common sense, is not subject to a deposition here. If we go to Google, the Office of the Attorney General, then we're looking at it, but I don't think that requires you to go through this with a fine-tooth comb and say, topic 32, topic 16, is it relevant, is it not? I mean, as a general matter, we have some cases on our side, the SEC cases, which I think are quite relevant, Gandy, Contrarian Press, Rosenfeld, would say we look at the topics and say, if this is inevitably and inescapably going to lead to a deposition where privilege is invoked for 6 hours, that deposition just doesn't happen.
Yeah, but my question's a little different. Assume for a second, I know you don't want to, but just assume the state has to sit for a deposition. And then the question is, in Midland, they put 18 topics, and Victoria put 32 topics. So we've got, quick math, that's 50 topics. If we decide that the state didn't meet its burden, because you agree, right, that the state had the burden as the party resisting discovery to prove its objections.
Yes.
If we find that they didn't meet their burden on one topic, that would be an abuse of discretion, right?
Well, I want to be careful there because you're looking at the trial court's decision through an abuse of discretion. So maybe in the trial court we had the burden, but here you're looking to what the trial court did. So I don't think it's a de novo question. So
Well, I agree with you.
Okay.
But, so we got two questions. One's an interpretation of a rule.
Yep.
Pure question of law. And if the trial court missed that question of law, that in itself is abuse of discretion. But secondly, then you look at the topics, and if the trial court incorrectly sustained an objection to one of those topics, wouldn't that also be an abuse of discretion?
If you think it was an error as to one of the topics, then maybe you would send it back down on that one topic. Sure, I don't disagree with that.
But the, in the USAA case,
Right.
they raised USAA raises the same objection, saying, we don't know anything about what happened in the car accident.
Mm-hmm.
They know about it.
Yeah.
And so it's superfluous to take a corporate deposition, and the Supreme Court says no. But they say USA could have disclosed documents or referenced previously disclosed documents providing the information in its possession regarding liability and damages. That information, combined with lack of personal knowledge, could show that a corporate representative's deposition would provide little, if any, additional benefit. In other words, if you can show with documents, if we send you back and say, you got to go show the trial judge that you have disclosed all your contentions, you have disclosed in detail, and you have disclosed all your calculations of damages, and then ask the trial. That's different from just saying you can't depose the state.
It'd be a different analysis. I agree with you. Yeah, I don't think you need to get there, though. I don't think,
Of course not.
and I don't think you need to go line by line. I don't think that'd be appropriate for a mandamus review, again, where you're looking to a clear abuse of discretion. I'm not aware of any case where that is an appropriate role for an appellate court. I mean, maybe you could see that in a sort of de novo context, but here again, it's an abuse of discretion. So you're looking to see what was before the trial court, and again, the orders don't have the reasoning in them.
Before we run out of time, I want to ask
Sure.
a couple of questions about what you just mentioned. What was the record before the trial court? You, the state, as I understand it, filed some evidence in this court after the hearing.
Sure.
What is it that allows us to consider that evidence?
So I don't even really think you need to get into that because that evidence goes essentially to the equity component of the mandamus test. I think you can resolve this on the abuse of discretion prong by saying simply neither trial court abused their discretion. So we're not trying to use that evidence to sort of buttress the abuse of discretion point. It goes to equities and it goes to some sort of background information. I see that I'm out of time.
Did you give him his extra 5 minutes? You are out of time.
If there's no further questions, then we would ask you to affirm. Thank you, Your Honor.
Ms. Hartwell.
What we are seeking here is a deposition of the plaintiff. We don't want to depose the other side's lawyer. We just want to ask the party suing us some basic questions about their contentions, about the facts in this case.
And of course, those of us who've been around, like my friend Mr. McConico and other people in the courtroom, know what depositions are for. Is you go through this whole thing and you pull out, cherry pick a line here and a line there, take it out of context and try to make the witness look bad. That's why we love depositions. That's what's fun about them. That's, because it's, and then the other side objects to optional completeness, and around and around and around we go. And considering the other factors here, why did you not move to compel all these things, which your client knows whether they're doing any of this stuff or not? Why did you move to compel all of this? Why didn't you move to compel the disclosures rather than just hauling off and taking the depositions and see what happened?
You know, we have moved to compel on other discovery devices. We argued, in fact, a number of motions to compel on interrogatories just like last week in Midland. The state has refused to answer contention interrogatories in Midland, taking the position that doing so is improper because it would be providing legal advice. So we've got a very difficult situation on our hands where we're being forced to move to compel on every last thing. And at some point, depositions are ultimately a lot more efficient, and especially the corporate representative.
Again, I'm wondering, so the potted plant rule, so, the attorney representing the attorney with the Attorney General's office cannot say anything except objection. It can't explain why unless you ask them. So how does that work when they're both attorneys? This is not what depositions were set up for, I wouldn't seem like.
There's a federal case that addresses this in our briefing. I think it's Health Alliance. And it points to the fact that what we're talking about is a corporate representative deposition. So it doesn't have to be of the lawyer. It is someone speaking on behalf of the party in the lawsuit, answering questions on things like, yes, I'm claiming these damages. No, I'm not claiming these damages. Helping to narrow the issues for trial. And those are kind of basic forms of discovery that we should be allowed to secure, that we just can't get complete answers to those things through written discovery. And we can't get the answers to some of those basic questions through expert discovery either, because experts have their narrow area. And we can't, for example, the state is alleging an injunction in both cases, which I find remarkable that they're saying consumer harm is not relevant when they're seeking an injunction to prevent against consumer harm. But we're allowed to ask factual questions related to things like the request for an injunction where expert testimony isn't going to cover those issues. So there are just significant gaps here that are left in our ability to get discovery if we don't get a corporate representative deposition. What the state is ultimately saying is, because we are the state of Texas, we get a pass on the rules of civil procedure. Boil their arguments down to their essence, and
No,
that's what they're saying.
Just one rule of procedure.
Really, all of them, because when you think about this argument that, well, no, really, for example, the hearing in Midland last week. Well, we're sort of the lawyer, we're sort of the state, so we have all of these protections. We don't really have to answer any of your questions. We get to sue you. We get to have 150 hours of depositions from you, but you don't get a single hour of deposition from us. There's a fundamental fairness problem with this position, and I would suggest that there are implications of this position, not just for this case, but for future litigation involving the state. Thank you for your time today and the opportunity to present argument.
Let me ask you one last question that I
Yes.
meant to ask Mr. Cole, but he ran out of time. The way that a civil enforcement action gets filed, as I understand it, is that a particular agency finds out that there's been some violation of a statute. And they refer the matter to the AG's office to file suit. As I have seen it, some of these suits are filed in the name of the agency, and some of the suits are filed in the name of the state of Texas. Mm-hmm. How does that get decided, and who decides it? Do you know?
I will be honest and say I don't know the answer for every context, Your Honor. I know in this context, the statutes that are at issue specifically say that the AG brings suit to enforce the statute in the name of the state of Texas. Yeah,
the agency, in a lot of these statutes, the agency can bring the suit, or they can refer it to the AG's office, or maybe they have to refer it to I don't know who makes the decision about who's the plaintiff.
I believe that's usually set by statute, Judge, and I know that there are many cases where the AG would be bringing suit to enforce a statute on behalf of the state of Texas, which is why I say the implications of this issue are significant. Thank you.
Thank you. The case is be submitted. We'll stand adjourned for about 5 minutes while we change the town.
the nerdy lawyer history.
That's right. No one besides you.
Yeah.
Next case on the docket is 1524-00010, Texas Department of Public Safety et al. Versus Texas Tribune et al. Let's see, I have Ms. Baumgardner for the appellants. Are you splitting your time, or
I've
20 minutes? You can reserve 5 for rebuttal.
reserved 5 for rebuttal, yes, sir.
Thank you.
Thank you, Your Honor.
You may proceed.
Thank you, Mr. Chief Justice, and may it please the court. The most straightforward way for the court to resolve this appeal is to hold that summary judgment was improper because the plaintiffs have failed to show that the law enforcement exception does not apply as a matter of law. Now, because that's the heartland of this case, I'm going to spend my time today talking about that. But before I get into that, I think it's important to say a few brief words to clarify the scope of this appeal, so let's start there. The only materials that are responsive to the plaintiff's public information requests are the materials that existed and that DPS possessed on the date they submitted their requests. Now, critically, my friends on the other side have not disputed the legal position that I've just articulated in their response brief, which makes sense because it's based on a couple of black letter principles of Texas law, namely that a government...
They just say you didn't raise it in the
That's
trial.
right, Your Honor, but they're wrong about the waiver argument, and here's why. The PIA, and in particular Section 552.321, which is the section they've sued us under, just waives immunity to the extent that we have to disclose. So because the scope of what we have to disclose is a jurisdictional question, when we can't waive jurisdictional arguments, we can bring that up. But that's the extent of what I wanted to say about the scope of the appeal. I just wanted to say it as a point of clarification from the beginning so we all knew what we were working with. But we can just turn to the law enforcement exception right now.
Let me make
Yes,
sure
Your
I
Honor.
got that. I thought you waived your plea to the jurisdiction in the trial court. Am I wrong about that?
Excuse me, Your Honor, I can't speak. We
There
have
was
filed a
some
plea to the
deal about,
jurisdiction.
they dropped their requests, and so you waived your plea to the jurisdiction.
There was an agreed judgment, Your Honor, where certain requests were the subject of the plea to the jurisdiction, but there was an agreed judgment where the parties agreed we don't need to dispute those anymore. So then we settled that. But we can still make this particular jurisdictional argument even now, even if we didn't make it in the trial court because it's jurisdictional. But we can just turn to the law enforcement exception now because, as I mentioned, that's the core of this case. And as the court's aware, we relied on a couple of different subparts of that exception, and we can just take those in alphabetical order, A1 and then B1. So let's start with A1, which is the section that says that a governmental body is not required to disclose if the disclosure of those particular records would interfere with detection, investigation, or prosecution of crime. Now, we have met our burden as a matter of law to show that that exception applies because of the district attorney's affidavit. My friends on the other side have raised a couple of arguments against that, but they're wrong about all of them. We know that the amount of testimony, in other words, like they say we haven't sufficiently explained, but that's wrong because in Paxton versus Escamilla, the third court indicated that testimony that's even less than what District Attorney Mitchell provided here is sufficient as a matter of law. In that case, the court was determining whether release of deferred prosecution agreements would interfere with prosecution under A1 in particular. And the court looked at an affidavit of an assistant county attorney, and the assistant county attorney just said that release of those particular materials would interfere with prosecution by generating excess publicity and causing due process problems, and there was a risk of, I think, jury bias, but maybe I'm misremembering. And the third court said that was sufficient. And that makes sense because often, my friends on the other side have mentioned about 4 or 5 cases on page 38 of their brief that say that that amount of explanation that an affidavit by itself isn't sufficient, but those cases actually aren't 108A1 cases, and yes.
This is what puzzles me about this. So you're arguing there's a fact question and we got to go down for trial. I've never heard of a PIA case, maybe I just haven't been listening, that's presented to a jury.
Your Honor, they're often, the important point that we're making here is just that they weren't entitled to summary judgment on this particular
Right, so
motion. It doesn't have to.
You're entitled to go back and have a trial, and I am aware that these cases, open records cases, often tried to the court.
That's right.
But if it can be tried to the court, it can be tried, is there some reason the jury guarantee doesn't apply to these cases?
I might be misremembering their petition, Your Honor. I don't remember them asking for a jury trial at all.
Yeah, I
but
think it'd be crazy to, because
Right.
the problem is, of course, and the best reputation of whether these documents have anything to do with ongoing investigations or prosecutions is the documents themselves. The documents themselves are always the best evidence. And they cannot possibly, since they haven't seen the documents, make an argument that this document and that document shows that this is just they're trying to avoid being embarrassed. This has got nothing to do with that. So how do they raise that when they can't see the documents?
Well, Your Honor, first of all, I want to acknowledge what Your Honor has said and just say that's just how the law enforcement exception works. We totally understand that it's often not prudent in the context of these very sensitive proceedings, like investigations and prosecutions, like Your Honor mentioned, to reveal those documents to anyone we don't have to reveal them to as a matter of law, and that we would therefore waive our exemptions by disclosing. But Texas courts have regularly relied on this kind of testimony that the district attorney raised. Now, Your Honor's asking how are they supposed to know, and Texas courts have recognized in cases like Paxton versus Escamilla and in Levin also, that sometimes the requesters just don't know, but the best evidence is actually, if short of looking at the documents themselves, which the trial court can do, it can look at the documents in camera, and ORD
Not
also
in this
reviews a
case.
representative. Sir?
That's the problem. The problem in this case is that we're talking about a couple of terabytes of data storage. So according to Google's AI, 1 terabyte of data is roughly 6.5 million PDF pages, enough to fill 1,300 physical file cabinets. Now, I know a bunch of it is video, and that takes more terabytes, but a terabyte of video equals 250 feature-length movies. So I know as a fact that not a single person in this courtroom ever has or ever will look at all these documents. So how in the world are we supposed to?
Your Honor, it's true that that this amount of data, it's often not prudent for us to, for a court to be able to look at that in camera. That's what the representative sample idea is for. ORD employs that, and so courts can do that. But
And the problem with the representative sample is, so the statute clearly says the court clerk, trial court clerk, if you submit something in camera, which apparently you did on thumb drives, is supposed to file that with the Third Court of Appeals. They never did with the Third Court of Appeals. When I found this out 3 days ago, we asked for it. And when the Third Court of Appeals didn't transfer it to us because it had never been sent to them, and so we get it and we can't open it. So now, how are we even supposed to look at the representative sample? I'm not blaming you for not requesting it, because as I read the statute, it says the clerk shall forward that to the Court of Appeals, and they didn't. So now, how many PDF pages is the representative sample?
Your Honor, I'm afraid I don't recall the answer to that. But what this court is
You
actually...
looked through every page of it.
I'm afraid I haven't, Your Honor. But the important thing that the court has to decide is what we're dealing with is actually, did we meet our burden on summary judgment? And we did, because Paxton versus Escamilla tells us that that's sufficient. And so what the
Let me stop
plaintiffs...
you for a second.
Yes, Your Honor.
Paxton versus Escamilla is from another intermediate court of appeals.
That's right, Your Honor.
So it's not binding on us.
That's right.
So you're saying Paxton versus Escamilla is what? It's highly persuasive? Because you're basically saying Paxton versus Escamilla, we followed it, we did an affidavit, therefore we win. And that's not, it doesn't seem quite so simple to me.
Well,
I guess could you take us through like a textual analysis, since that decision's not necessarily controlling on us, and we're gonna be looking at how to interpret the
Right.
specific language that we've got in the law. Could you just walk us through the language and how that specifically applies to each category that you're asking us to?
I can discuss with the court the language of the statute, yes. But
Yeah.
before I do that, I want to say something briefly about Escamilla, because Justice Field just mentioned it. Your Honor's right that it's not binding on this court, but it's the most on-point case that this court has been given, because the cases that my friends on the other side have mentioned on page 38 of their brief are not 108A1 cases. There are cases about other law, other PIA exceptions, or sometimes not even exceptions. And the reason that matters, Your Honor, is because, as Chief Justice Brister mentioned a few minutes ago, these kinds of proceedings are really sensitive, prosecutions, investigations, and so often it's not prudent to say very much in an affidavit. The DA here, DA Mitchell, said a lot more in her affidavit than the Assistant County Attorney in Escamilla did, and a lot more than ORD requires, I'll say, for the 108A1 exception as well. But that's why we reference Escamilla. It's highly persuasive, and it's the most on-point case that any of the litigants have given this court on this issue, and because their cases are not 108A1 cases.
So both at
Now-
the Open Records Division, Attorney General's Office, trial court, it's not your burden to conclusively prove law enforcement applies. It's just is it to conclusively prove law enforcement exception applies, or to raise a prima facie case that it does?
Your Honor, generally Texas courts have relied on the kind of testimony that we've put forward here, the DA testimony. That's sufficient for us to meet our burden to show that the exception applies as a matter of law.
It sounds like a prima facie case.
The plaintiffs certainly have the opportunity to rebut it. They haven't done that, but before I talk about that, I want to
But-
talk about, yes, Your Honor.
Can they rebut it? I guess that's where
Yes.
I'm frustrated procedurally, is anyone sitting in this courtroom can understand I'm a procedural person. And if you procedurally are on summary judgment, and you have to prove something as a matter of law, and then you have an affidavit that at best is vague as to the how and why that this is going to interfere with the prosecution when the primary suspect is dead. How do you know how far that affidavit has to go to prove something as a matter of law? If it is confusing to me as well, and I got that in your first question, that we're here on summary judgment. You're saying there's a fact issue. That the
She's
trial,
saying there's no fact issue.
well, but the trial court said summary judgment was proper, so if you want to reverse the trial court, you're having to say as a matter of law, it goes the other direction, or there's a fact issue, one or the other, right?
Yes, Your Honor. There are several things in Your Honor's question that I want to address. The most important one to me seems like how procedurally is this supposed to work. There are a few reasons that the plaintiffs were not entitled to summary judgment, but one of the reasons the plaintiffs could have gotten it is they tried to rebut the presumption that public officials act in good faith. They have not attempted to do that.
But
If they
isn't
thought
that-
that, yes,
isn't
Your
that
Honor.
I mean, does that presumption apply? And I guess, I know your answer is going to be yes, but my question is really why. If the very law enforcement agency you're asking for records from is the one that you're questioning whether they actually acted in good faith in the underlying facts of the case, do we get the good faith presumption when the very reason the press is wondering what happened is that they're saying the DPS didn't act properly?
Your Honor, we're not saying that, what we're talking about here is the testimony of the district attorney. My understanding of what the plaintiffs are saying is that no one is disputing whether the district attorney has acted rightly. My friends on the other side can make whatever inflammatory allegations about DPS they'd like to make. But the testimony we're talking about here is the district attorney's, not about whether the district attorney has acted. Nobody's disputing whether she's acted rightly. And that is really important because there are sort of three reasons procedurally that they were not entitled to summary judgment. One of them is the one I just mentioned, the presumption of good faith. The other one is that the non-movement at summary judgment is entitled to have evidence read in their favor, and that's us. And the other reason is the one that Your Honor and I have discussed already, which is that the entity, Texas courts have recognized that the entity in the best position to know what would interfere with prosecution is the actual prosecutor, not a bunch of news outlets. Now, I do want to address Justice Ferris's question about the language of the law enforcement exception, and that exception is actually pretty broad in its language. Interfere is a pretty broad word, would interfere with prosecution without specifics as to how. There's also no time limit in the statute. So what the legislature has done in that broad-ish language is recognize really how law enforcement works as a practical matter. No good investigator worth his or her salt is going to turn over information that could interfere with the prosecution while the prosecution is ongoing. And in enacting 108, the legislature has recognized the profound public importance of seeking justice to be done through investigations and prosecutions.
So how many prosecutions are ongoing?
Well, Your Honor, some of these things are sensitive, so I can't speak to them in an
No,
open
I mean,
courtroom.
how
But
many people have been indicted?
But I am aware of 2 officers that have been indicted. Yeah, those are the ones that are public and that are out there. So those are currently going on.
And anything that exonerates them, you would have to disclose under Brady.
Yes.
Rule regardless.
Yes.
So all we're talking about is stuff that would, and anything that implicates them, you'll want to use it to trial again. They'll want to use it trial against them. So what are we talking about? I'm not asking for particular things. I mean, I'm just wondering, body camera footage. It is what it is. It shows what it shows. It's not going to change. I mean, I understand the problem about witnesses, and we can talk about those, but that is not going to change. It is what it is. And why does that need to be kept secret?
Your Honor, I'm about out of time. May I have a few
Sure, you
seconds to
bet.
answer the
Well,
question?
and to use an example from the briefing, the radio traffic going on at the time was something that's argued should be withheld. So talk about that.
Sure. So the concerns that the district attorney has articulated are not necessary, well, are more along the lines of this could interfere with witness recollection, like Your Honor said. The fact that the footage isn't really going anywhere doesn't really have anything to do with those particular concerns about potential jury bias or witness recollection, because if those kinds of things are released to the public, they can interfere with public opinion, and the district attorney has testified that it is already interfering with witness recollection. Now, Justice Field, your question about radio traffic footage, that falls more under the B1 category, which is information, internal records that if released would interfere with the way police officers do their jobs. It can really reveal things about the way officers investigate crimes, patterns they're looking for, the kinds of things that they're saying to each other while they're engaging in these investigations. So that's why that should be withheld under B1 as well.
Well, this is starting to sound like everything, though. I mean, at some point, we have to draw a line that not, every single piece of information that may be picked up in the course of these investigations is necessarily something that, is so pertinent to the investigation that it needs to be shielded. I mean, what do we use to draw the line where we have such a huge volume of information?
I think that what Your Honor has just articulated is true as a general matter. And I think one way that the court would know that is if the governmental body hadn't been specific enough in just explaining what they wanted to withhold. But we have been specific enough for the reasons I've already explained to the court. If the court has no further questions.
I do want to ask a question
Yes,
about
Your Honor.
just the temporal nature of the objections to producing these things. So what happens when the prosecution is over? Do these records become public if someone requests them?
If someone requests them, Your Honor, a DPS and the DA are willing to disclose the lion's share of DPS's own information. Obviously, there are some things that are relevant to officers' training and things like that, and those might be things we wanted to withhold under 108. But once the prosecutions have concluded, then if someone makes a new request, as Your Honor just mentioned, and that's an important caveat here, if someone were to make a new request, then once that had concluded, we wouldn't, 108 we wouldn't think was implicated anymore. There might be other exceptions, but 108 wouldn't be implicated anymore.
Thank you. Is Prather, is it?
Yes, Your Honor.
Your Honor, may it please the court. My friend on the other side is incorrect in three very significant ways. One is with regard to the presumptions under the law, two is with regard to the burdens, and three is with regard to the scope. And I'd like to first start with the presumption. Under the TPIA, information is presumed public. That is significant because the legislature has provided that
Except for the following 80 exceptions.
there are a number of exceptions, you are absolutely correct, Your Honor, and they have grown over the years. But even those exceptions under the Act are to be construed narrowly. And that is not what DPS is advocating for here today. Instead, what DPS comes before this court with is an invitation to read into the statute non-existent mandatory exceptions and confidentiality provisions that are not there. And if this court does what they are asking, as Justice Ferris has brought up, they would be cloaking in secrecy the entire investigative file forever, not just for a finite period of time.
Could you tell us of the 2.8 terabytes, how much has actually been disclosed at this point, or is that?
Virtually none, virtually none. And this is really important. And so they're wrong on this, on the presumption. They're also wrong on the burden. Our burden is to establish that we asked for the documents and the documents were not given to us. Their burden is to establish that the exemption applies, and they have failed to do that.
Why
Again,
does the district attorney's affidavit not do that?
the district attorney's affidavit is not specific enough. It doesn't identify any specific documents as to why or how those specific documents or materials would cause an interference with the investigation. And her affidavit, if you
But
look at,
with 6.5 million documents, that's unrealistic. I know you objected to the representative sample, but what in the world do you expect us to do with 6.5 million documents?
I hear you, Your Honor, and I actually think what the trial court did was an incredibly thorough review of all of this. And so let me go back to the why the affidavit is insufficient, and then I'll tell you what the trial court did. So the reason the affidavit is insufficient is under the ORD 252 and under 434, both of which were dealing with law enforcement exemptions. The Attorney General very clearly said when you claim an exemption under 108 and that it applies to an entire file or an entire report, that is simply insufficient. We did, of course, also include case law dealing with this insufficiency of affidavits as well. In the Mitchell affidavit, what is most interesting about this is her express concern is about getting a thorough and complete investigation. She's received that. So just to sort of step back a little bit, the shooter is dead. The investigation is complete. A1 can't apply.
Your position, I know you quote Mr. McCraw, or Officer McCraw, but that it's a conclusive fact that DPS's review is complete. There's not a complete final report.
There is a
mentioned.
complete final report. That's the 2.8 terabytes of data. And so that gets into Your Honor's question about...
It's the whole thing.
Right. So that gets into Your Honor's question about, how can we look with this massive information? So, and this also impacts the scope issue, right? So what happened in this case is we had a summary judgment hearing in March. The investigative file was concluded. The investigation was concluded in February. Colonel McCraw testified to that. Then in March, we had our summary judgment hearing. In June, the court issued a letter ruling. That letter ruling is at CR 1610. And in that letter ruling, she asked for DPS to put together a list of proposed redactions organized by category, mandatory exemptions, and any additional redactions required under the law. Okay, that's where this scope issue comes in and where the federal law issue comes in. Nothing was brought up about scope, federal law, nothing, right? DPS submitted their proposed final judgment in July, mentioned nothing about this, and then to deal with the magnitude of documents that Your Honor's concerned about, rightfully so, what the court said is, come back in September, so now we're talking 3 months later, and on September 14th, we're gonna have a hearing, and we're gonna discuss the documents, the magnitude of documents, and I want you to bring with you logs of what all these documents are, and I want you to list in the logs what mandatory exemptions and other confidential under other law provisions that you want to have imposed. So they produced these logs, and these logs are in the record. They're at CR 1978 to 2041. Okay, there's a whole column, mandatory exemptions. Says nothing about FOIA, says nothing about Privacy Act, also says nothing about some of these are not responsive documents because they're after the TPIA request. Nothing. They present to the court, this is the entirety of the Rangers report. They describe it as a complete copy of the Rangers report that is responsive to the requests. They describe it as being 3,000 pages, and then they give us the logs. The court says, okay, this is too much. I need you to give me exemplars. DPS, you select your best documents. This is you selecting, so it goes back to they control all the information, right? You give us your best documents, your best exemplars for each of the categories that you think have mandatory exemptions or confidential under other law, again, no mention of FOIA, no mention of Privacy Act. Come back to us in another month. So now we're into October. October 12th, we come back. So the September hearing is the third reporter's record. The October hearing is the fourth reporter's record. Fourth reporter's record hearing, they come forward with exemplars. They have 14 categories of mandatory exemptions or confidential under other law. They impose this or confidential under other law under 552.101 4 times out of 14 different categories. None of them mention FOIA, none of them mention Privacy Act, okay?
But it is, I mean, they do mention other law.
They do.
Right.
I'll tell you what they mention is they mention common law privacy, they mention homeland security, and they mention criminal history record. Those are the 3 that they graft in under 101. They don't ever graft in FOIA or attempt to graft in FOIA or the Privacy Act, neither of which apply to state records. But instead, they present, these are our best examples to the court. And some of those examples, in fact, the very first example that they present to the court is post-stated after the TPIA requests. So they have made a representation to the court that these are the representative records. And now they come before this court and they say, King's X, some of those are not representative records after all. They don't fall within the scope.
Well, if they're, so I know that you've made the waiver point about the documents that were produced post FOIA request, but if that argument is not waived, would you concede that those would not, that the summary judgment wouldn't have been appropriate to those documents?
No, Your Honor, and here's why. Because what courts do is, as y'all know, courts rule on evidence presented to them. And this is the evidence that was presented to them by DPS. Here are the responsive records. Otherwise, what you would end up having is you'd end up having this endless cycle of people throughout litigation saying, oh, here's a new TPIA request. Oh, and here's another one, new one. Today, tomorrow, the next day, right? You'd have this endless cycle. Instead, what courts do is they rule on the evidence presented, and that evidence presented by DPS was 2.8 terabytes of data, the entire Rangers report. In addition, the legislature has actually done exactly what Your Honor suggested in 552.103, where they said for the litigation exception, this is to be decided based on the facts as of the date of the request. That is nowhere else in the TPIA, which means that is not the general rule. Similarly, when it comes to grafting in the federal law, which does not apply to state records, the one time the legislature said, we're going to defer to federal law in the TPIA was in 552.029, dealing with inmate substance abuse facility information. And there they said, we're going to defer to federal law.
But it seems like there would be a huge problem if, you do have these types of investigations where you have state, federal, local, everybody together. If, federal entities couldn't rely on, federal protections for things that they're sending to try to help.
Well, you're right in that this was a collaborative effort, but DPS was tasked with leading the charge in this. And DPS didn't notify the federal folks when the original request came in under 305 like they're supposed to do. So what they did was we actually had a summary judgment hearing set. They asked for a continuance. Then in between the original setting and the continued date, then they notified the federal authorities. And then the federal authorities wrote these letters, none of which are evidence. They're not summary judgment evidence. They are purely argument that they try to, again, graft into their summary judgment motion, which they can't do under Texas Rule of Civil Procedure 59. And they characterize it as arguments, and they characterize it as the views of the federal government. And that simply is not appropriate to be grafted into a summary judgment motion where it's not evidence. And if you look at those letters actually do not say anything about the facts as well. They don't attach the documents that they're talking about, which is required under 166 AF. They simply say, we don't want this information to get out. On the logs that are provided in the record, those logs, they list the federal documents. They don't say that there's any exemption that applies to those federal documents. And so you have a trial court that has done an incredibly diligent job going through all of the different materials that have been supplied and represented to it as responsive documents,
Let me
making
ask
this
you,
ruling.
On there is, I assume, civil litigation filed by some of the families.
I assume so, yes, Your Honor.
You don't know anything about that?
I know what I've read. Is it part of the record? maybe a footnote to it here or there. We don't represent the families.
And of course, I assume lots of the analysis, attorneys involved and all that kind of stuff, is trying to determine what went wrong and what we can do better next time.
Which is why it's so
In
important for the public to know.
civil litigation, of course, that's all the trial will be about. You know, if you subsequent remedial measures are all plaintiff's attorneys look for, because then you admit you didn't do this right and therefore you owe us millions. Now, against the state or the city, you probably can't recover millions, but you can recover something. Now, criminal, that's not as big a problem because then the prosecutor you exercise discretion. Should we indict more people because they didn't do something right that in hindsight we see should have been done differently and they should have gone in earlier and all this stuff. So I'm just, but of course once we hold it's public, I understand there's no exception for civil litigation usage. It's got to be in law enforcement, but we do have 2 pending indictments, prosecutions ongoing. And again, I'm just wondering, can you help me with the criminal case? Is that going to become the focus of the case? We're going to forget about this young man that shot 20 people, and we're just going to focus the whole trial on the various police officers or agencies did this and that wrong. I assume they'll have to do that in the case with the 2 Uvalde police officers.
Your Honor, I mean, under Brady, don't they get that information anyway?
I'm sorry.
Under Brady, don't they get that information anyway? I mean, that's probably why the district attorney in her affidavit, and even her representatives at the summary judgment hearing, who did argue at that hearing because that was before the intervention was struck, they didn't argue for this information to be cloaked in secrecy forever. What they said was, we aren't advocating for this to be in a vault forever. We just want to get a complete and thorough investigation, which they have. So A1 simply doesn't apply here. And then what now is being argued, and it was not argued at the trial court level, is B1. And B1 is actually more dangerous because B1 is an attempt to cloak the entire file in secrecy forever. So we're talking about the most significant law enforcement failure in Texas's history, that they would like to cloak in secrecy forever from the general public. The public interest couldn't be higher. I mean, as you know, Your Honors.
Well, they've assured us not,
And
so we won't know about that for some time.
except that we cited in our summary judgment brief examples of all the times that they had invoked the rule to prevent the public from having the information forever. And that is part of the record.
Well, here isn't the problem, though, that we have some pretty broad statutory language that we have to deal with when we're looking at the facts and whether there was just a fact issue. And so even if we might like, as a matter of policy, to prefer more openness, more disclosure, at the end of the day, we're kind of constrained to the text that the legislature's given us, right?
And the text that the legislature has given this court is text that they have specifically said should be interpreted narrowly. And in fact, when 108 was adopted, the legislators who were involved in the adoption of 108 specifically warned against this exact issue. They said that that 108 should not be permitted to be used to allow law enforcement to operate under a blanket of secrecy,
Sure.
which is exactly what they're trying to do here. By moving from an A1 argument, which can't apply because the investigation is complete, to a B1 argument, which now they're saying applies to internal records. Now, that shouldn't apply to the immutable evidence that Colonel McCraw talks about coming out, the body camera, the dash cams, things along those lines. But what they're...
It sounds to me like what you're saying is we shouldn't believe the district attorney, which of course is a credibility, so we need to go to trial to see whether the trial judge believes the district attorney's affidavit or not. Or we should look through the documents to see whether that's what they do, which is impossible.
I don't
And
think,
so I'm wondering, how do we reject? I think the standard is a prima facie case, and I think the affidavit is a prima facie, raises a prima facie case. And I recognize that is frustrating when you can't have access to the documents, but I just don't know, what would you have us do?
I don't think that the affidavit, it's not a matter of a credibility determination, it's a matter of disagreeing on the law, disagreeing with the
Because
assumption
it
of
doesn't
the
go
law.
into greater detail.
It doesn't go into great enough detail. It's not sufficient under the law as far as the specificity goes. It doesn't meet the
What would it
standard.
have to say? What would it have to say if, they make the argument under Escamilla? In your view, what would the affidavit have to say to meet their burden?
Yeah, so Escamilla is a very different case. Escamilla is dealing with very specific documents. It's dealing with documents that are having to do with deferred prosecution agreements for unexpired terms in which charges can still be brought. That's a whole different animal than 2.8 terabytes of data that is evidencing the biggest abject failure, as Colonel
We'd agree
McCraw
to
has
that.
said it.
That's different. We can't look at the documents. basically.
Right, but there could have been more specificity. There could have been any specificity. And under B1, which is a new argument, it's not one that they made at the trial court level, they provided no evidence that these are internal records or policies or techniques that somehow are going to interfere with law enforcement in the
Let me
future.
interrupt you and ask just briefly about the district attorney's intervention. Surely she has an interest, if really, good faith or not, if she thinks this is going to harm her prosecution, and she's got at least 2 people indicted, surely she's got a right to stand up in court and tell the trial judge, don't let this stuff go, it's going to ruin my case.
So, Your Honor, I think there's a difference between an interest and a justiciable interest. That is a very difficult
right.
word for me. Here she doesn't have the justiciable interest, right? She doesn't possess the documents DPS does, and this goes into the fact that 108 is a discretionary exemption. DPS could produce the documents tomorrow if they wanted to, and the DA would have absolutely nothing to say about it.
Especially if she's not allowed to intervene.
She's not. She's
I
not.
know,
And
but why? Why?
because she doesn't have a justiciable interest. They're not her documents. These are not her documents to control one way or the other. She does further complicate the issue, and
Well, there's plenty of other places, like the Boeing case, where, the Port of San Antonio may not care whether Boeing's information gets out. Boeing does, and so they intervene. Now, there's a special provision in the statute that says they can do that but it's not their documents. They don't own the documents.
it's Boeing's contracts with the Port of San Antonio.
Yeah,
Yeah, these are not her records. These are the records that DPS, or the public's records that DPS holds. And here you've got a 3-prong test, right? It's not just she has to have a justiciable interest, which she doesn't, because she couldn't have sued and these aren't her documents, but also she would further complicate the issues. She has.
how?
Well, one of the issues that's been brought up is that her chief investigator, was on the scene the day of the actual tragedy, right? Another issue is she says that her interests are entirely aligned with the DA's, or with DPS. And so how is her presence essential if it really is just duplicative? She just doesn't meet the 3-prong test, and the abuse of discretion standard is so high that the trial court should be given deference on this.
I'll give you another couple of minutes. since-
Well, I'd like you to go back and finish your answer on what the affidavit specifically should have said.
Well, the affidavit should have specifically identified any documents. They identified no documents, but any documents that would get out, that would harm, that would interfere with the law enforcement investigation or prosecution. Now, she didn't do that, but she also didn't ever mentioned a concern on the prosecution piece of it. She only mentioned a concern about getting a complete and thorough investigation, which she has gotten. So A1, again, can't apply. There's no pending investigation. There's insufficient evidence. B1, there was no evidence presented, so it can't apply. All you have there is you've got a situation where they're trying to bootstrap in, oh, if these policies and procedures get out, that's going to harm us, even though those are the exact policies and procedures that weren't followed that day, that Colonel McCraw has already talked about: Columbine, active shooter training, alert protocol. That's what complicated and compounded the tragedy that day, and that's why Colonel McCraw has been so himself publicly saying this information should come out. The public is in the best place to determine what happened that day.
Thank you, Ms. President.
Thank you.
Ms. Baumgartner, you've got 5 minutes.
May it please the court. There's a lot that I just heard, and I've got about 6 or 7 things I'm going to try to get through in 5 minutes. So let's see if I can do
Could I ask you
it.
a question? I'm
Sure.
sorry to interrupt your time right
That's
off,
fine.
But is there no B1 evidence?
First of all, Your Honor, I think we need to clarify something about B1. That's actually one of the things I wanted to bring up. My friend on the other side seems to have mistaken the text of the statute. We did bring up B1 with ORD. We did. And we discussed at pages 304, 308, and 312 of the record. We discussed A1 in trial court, but we did raise it with ORD, Your Honor. And also, my friend on the other side seems to think that that B1 doesn't apply here because it's about after the prosecution. I believe she's referring to B2 and A2, which we have not relied on in ORD and are not relying on now. Moreover, my friend on the other side said that A1 doesn't apply to prosecutions, but I'd like to read the text of A1 to the court. Information held by a law enforcement agency or prosecutor that deals with the detection, investigation, or prosecution of crime, ... is accepted if release of the information would interfere with the detection, investigation, or prosecution of crime. Okay. Let's see. And she concedes that, yes, Your Honor.
Why would the affidavit have to say how or why the specific documents would interfere with the prosecution of a crime?
Your Honor, saying why would it or why wouldn't it?
Wouldn't the affidavit have to prove as a matter of law that exception applies, that this will in fact interfere with a prosecution?
It has already done that, Your Honor. First of all, my friend on the other side says that we ought to have explained particular documents, but often revealing what documents we have or why certain things would interfere with an investigation or prosecution can reveal things about the investigation or prosecution that are better kept private. As Your Honor is aware, these kinds of proceedings are highly sensitive, and sometimes slicing off a piece of the investigation and revealing it can reveal stuff about the slice you didn't slice off. So that's
Procedurally, it's not possible to present, I mean, I don't know the answer, but the question I'm asking. Why couldn't a trial court in their in-camera review have a version of the affidavit that actually explains? I'll tell you, I've just having come off the trial court bench, I feel tremendously
Sure.
for this trial court judge.
Sure.
How in the world are you supposed to make a decision
sure.
with this information, much less a decision on summary judgment? So is that not possible? They're just supposed to take the DA's word for it?
Your Honor, I have a couple of caveats to the answer I'm about to make. Generally, yes, they are. Yes, in that is sufficient as a matter of law. My friend on the other side hasn't actually cited any cases for her position that we needed to say more, and we provided one that's on point, and the reason she's articulated the Escamilla is different are not material for distinguishing purposes. So generally, yes, that's sufficient as a matter of law. The plaintiffs are welcome to try to rebut the presumption of good faith. And of course, Your Honor, the district attorney is under oath when she makes this testimony, so she can't lie about it. So yes, that's
Those
sufficient.
people never lie in court.
Well, they don't, Your Honor, but, well, of course they don't, Your Honor. Okay, next. We can't waive jurisdictional arguments no matter what happens in trial court. We just can't. That's the way jurisdictional arguments work. My friend on the other side said that the court has to rule on evidence presented to it, but it can't do that if it's not allowed to rule on the evidence as a matter of law or if it doesn't have subject matter jurisdiction over those particular requests. She also says that we didn't bring it up in our mandatory exceptions, but responsiveness based on time is not a mandatory exception, so we couldn't have raised it in our mandatory exceptions when we brought our spreadsheets to the trial court. I am trying to make sense of my notes. Next, she, also saying that the district attorney has to name document by document, really vitiates the whole idea of the law enforcement exception in the first place. Now, my friend on the other side referenced a couple of open records decisions that she thinks supports her position, but I'd like to point the court to a couple where all the agency said was, there's a criminal investigation ongoing. In particular, oh goodness, OR 2011-15545. Great.
Just send us a letter with that.
Great, I will do that. Okay. I'd like to say a few things about the district attorney's affidavit. My friend on the other side is incorrect about what the justiciable interest test is. The Texas Supreme Court has never asked whether anyone is the right defendant in the first instance. They just ask, could this person, if they were a defendant, have defeated the plaintiff's recovery in part or in full? My friend on the other side also says that the district attorney didn't mention prosecutions in her affidavit, but that's wrong. Clerk's record, I believe, page 1158. As the district attorney, I am obliged to see that any potential defendant is accorded procedural justice. There are more to that effect. We ask that you reverse.
Thank you. Ms. Baumgartner, before you go,
Yes.
will you undertake to deliver to our clerk under seal whatever you all gave the trial judge as far as a representative sample, with simple instructions that even I can access it? Because I've tried, spent 15 minutes this morning trying to access it and didn't get anywhere. So I'm sure it needs to be password protected, but it needs to be in something that our government computers will open and we can have access to it.
As I have a government computer myself, Your Honor, I understand. We will undertake to do that. We'll do our best.
Thank you. We'll take a 5-minute break. Thank you for your patience. The last case on the docket this morning is Crowley ISD versus Carl Stoneham. Who's present for the appellate?
David Campbell.
You may proceed. You've reserved some time?
Yes,
Or
Your
not?
Honor, reserved 5 minutes for rebuttal. Thank you, Chief Justice Brister, and may it please the court. In this case, the independent hearing examiner, certified by the Commissioner of Education, after a discovery had been conducted and an evidentiary hearing had been undergone, determined that good cause existed to terminate a teacher's employment contract because the teacher used unreasonable force against a student.
But didn't the hearing examiner use the wrong legal standard?
No, Your Honor. The hearing examiner did not. In this case, the first ground the commissioner used to try to reverse the hearing examiner and the board's decision was by claiming that it was arbitrary and capricious, but the commissioner's reason for that has been a little bit slippery. Because what the hearing examiner found in the decision was that the teacher's use of force was not consistent with the conduct of a person of ordinary prudence under the same or similar circumstances. If you asked a jury a question on this, I mean, that would be the jury question, and that would likely be all the court would have instead of the entire decision from the hearing examiner explaining how she reached that decision.
But is that the statutory language from the immunity for use of force statute?
So the statutory language, the key part of the statutory language in 22.0512, referenced then in Chapter 9 of the Penal Code, is whether there was a reasonable belief. And so courts in this context and in the related context of, say, official immunity, have found that because the belief has to be reasonable, it's not a subjective standard. We aren't just looking at whether the teacher legitimately had a belief. That would open the doors to chaos. Instead, there's a subjective element and an objective element. And so the subjective element is, did the teacher believe it? Usually that's not the real issue. The issue is, was that belief objectively reasonable? In this case, the hearing examiner in the findings of fact explained, after reaching a number of findings of fact in favor of the teacher, found ultimately that at a point, the restraint of this student on the ground became objectively unreasonable.
But isn't the test whether, when and to the degree the actor reasonably believes the force is necessary to further the special purpose? Like, isn't it not just a general reasonableness, but to further the special purpose? And if we look at the special purpose, then doesn't that special purpose have to be either keeping the school safe from an intruder or compelling compliance with the command to show ID? Like, how did the hearing examiner address that particular provision of the statute? Because I think everybody recognizes that the examiner made a reasonableness determination, but what I'm concerned is that language about necessary to further the special purpose.
So I don't think there's been much dispute in this case about that particular language. I mean, the question has been that there was an interaction with a student where the teacher was asking for the student's ID. The student refused to give it. Crowley ISD hasn't tried to defend the student's behavior. I mean, what the student did was inappropriate. He should have given the teacher his student ID. The issue came when the teacher decided not to de-escalate the situation, but tried to effectuate that special purpose of getting the ID in an unreasonable way. So in this case, I don't think there's been a dispute about...
So the unreasonable way was he stood in the door and said, no, there's a rule, you have to show me your ID, and I want your ID, and the student obstreperously said no, and apparently tried to push past him. Anyway, they end up on the floor, and all the other reasonable teachers don't intervene. They stand around watching while this guy pounds the teacher in the head. Now, how can that be? Seems to me the problem with the unreasonable people in the school is the people watching. I mean, why did...
Yeah. So, Justice Brister, obviously we don't have audio in the video, which would be helpful, right? What we do have is testimony from one of the other teachers who was there kind of from beginning to end. The coach who came by the classroom, and the student from inside the classroom called out Coach B. And what he testified to, and this evidence wasn't really disputed, was that he asked the student, why don't you just give Mr. Stoneham your ID? And the student said, I already showed it to him. I don't want to give it to him. I don't want to give him my personal property. Now, our position was from beginning to end, Mr. Stoneham made bad decisions by escalating instead of de-escalating the situation, by standing in the door, preventing the student from leaving. The hearing examiner found against us on that, and reasonable minds could disagree. So I'm not going to argue with you about that today. What the hearing examiner found is it may have been reasonable for him to stand in the door. It may have been reasonable for him to engage with the student. And this may go to your question, Justice Ferris. To engage with the student, there was disputed testimony about whether they threw the student down or whether they sort of stumbled ground. Again, the hearing examiner saying in the decision, and really this is something that the hearing examiner should not have done, but giving him every benefit of the doubt, and that's the hearing examiner's language, giving him every benefit of the doubt. I'm going to find that at the point they end up on the floor and the student is lashing out at him, maybe up to that point it's reasonable. In fact, not maybe, the hearing examiner found up to that point it's reasonable. The school board did not reverse those findings. They deferred to the fact finder, the independent hearing examiner, on those findings. What the hearing examiner found is 2 minutes is too long. After the blows from the student stopped, which, by the way, Justice Brister, one reason that it's not a good idea to engage in this kind of behavior is because, when you have a cornered animal is going to bite you, right? Military, you never want to prevent your enemy from retreating because it's going to increase losses, right? So, there's a reason to de-escalate instead of escalate.
Well, I just want to make sure, because it seems like the briefs are kind of talking past each other a little bit. So would you concede that if the examiner applied the wrong legal standard, that the commissioner was entitled to substitute his judgment, and then we review the commissioner's judgment for substantial evidence?
No, Justice Ferris, and here's why.
Okay.
I would direct you, so the Texas Supreme Court has addressed this statutory framework twice in the Ryu decision in 2020 and in Davis, the Montgomery ISD versus Davis case in 2000. In Ryu, reviewing the commissioner, this is basic legal sufficiency review.
But the commissioner never actually cited 22.0512, right? Or, sorry, the examiner never cited.
Right, and so this is my point. So if you look at Ryu, in that case, the commissioner engaged in the wrong legal analysis. In that case, the commissioner had applied a good cause per se standard, which wasn't appropriate. Legally, it was the wrong analysis.
Right.
So what did the court do? Did the Texas Supreme Court say, therefore, it's arbitrary and capricious, we're going to reverse you? No, they did what this court typically does. It looked at the record to see if the findings and the evidence support, in this case, the right legal standard. And so, in this case, I don't see that
But if we think that the commissioner's applying that standard for the first time, then do we have to review that just for substantial evidence?
So let me answer that in two ways, because I think actually you put your finger on something I want to make sure I don't sit down without addressing, because I think it's an important jurisprudential question for this court to answer, the right standard of review that applies. But just specifically on the legal issue. Nothing that the hearing, the commissioner said in his opinion, in essence, I'm left guessing as to what the hearing examiner decided as to whether or not it was reasonable for the teacher to use force. I don't think that this court could read the hearing examiner's decision and say that we're confused about how the hearing examiner reached her decision. She clearly viewed the circumstances from the point of view of Mr. Stoneham, looking at all the facts at play. She resolved many of those facts in his favor.
Yeah, but if she asked the wrong question, isn't that like a jury charge error where she, maybe her fact findings are correct, but at the end of the day, they don't fit the boxes that she needed to tick?
So if she asked the wrong legal question, then the question would be as in Ryu, as what the Texas Supreme Court looked at it. There it was, you shouldn't apply to good cause per se, so we look at whether the evidence supports the correct legal standard. That's the same thing that should have happened here. That's what the Edinburgh versus Villarreal case stood for, is that you can't just disregard the findings. If you disagree with the legal analysis, then you have to perform. What the hearing examiner did do is correctly lay out the legal standard, correctly lay out the standard that we're looking at whether a person of ordinary prudence in the same or similar circumstances would have done this. And so, could the hearing examiner have said more? Yes. Did the hearing examiner say anything incorrect about the legal standard? Absolutely not. do the hearing examiner's findings and conclusions give us all the information and give this court all the information you need to determine whether immunity applies or not? In other words, whether the teacher used unreasonable force? Absolutely. The hearing examiner's findings and conclusions give the court everything you need on that. Now, I've said there's a second answer to that question that I think is really important in this case. And that's because, as you see in the briefs, I mean, we are ships sailing in the night on the standard of review. And so I wanted to address that because I do think it's an important issue, and it's an issue that I'm not aware of any court really digging in and addressing. Under 21.307, and this is behind tab 1 of the oral argument exhibits, I just gave the court the relevant standard of review statutes from Chapter 21 because I think this is a fairly unique administrative process that involves multiple steps: the hearing examiner, the board, then the commissioner. And the commissioner sits as an appellate court that should be applying legal sufficiency review, deferring to the fact finder, the hearing examiner. But the wrinkle is in 21.307, we have this language that a court reviewing the commissioner's decision can't reverse it unless the commissioner's decision is not supported by substantial evidence. Now, what does that mean when the commissioner has no adjudicative fact-finding authority?
Well,
What courts?
didn't he accept all of the facts, except kind of the conclusions drawn from the facts as to how they fit in the statutory buckets?
So for the most part, I mean, he did quibble with what is labeled as conclusion of law number
6 and 8.
8. I mean, yeah, and I think it was the third 8 because of the numbering issue, right? So, and I actually, if you look at conclusion 8, I think there are actually 2 findings that are fact findings. The first sentence, the first part of that is clearly a fact finding. The second part is maybe a mixed question of fact, but I think clearly a fact, the kind of thing that you would ask a jury. And the commissioner has been clear in multiple decisions that we cite in footnote, I think 4 of our brief, Adair, Kinsey, Boyer, numerous commissioner decisions where the commissioner said in this administrative context, it doesn't matter whether things are labeled, unlabeled, what they're labeled as, you should, if it's a fact finding, treat it like a fact finding. So to that extent, yes, the commissioner accepted everything labeled as a fact finding, but quibbled with those and also quibbled with the language that wasn't labeled, that was sort of a discussion section in the decision.
So I feel like you're kind of leading up to it, but you're reading my mind. The problem I'm having with this case in the briefing is a standard of review.
Yes.
And the statute seems to say we're reviewing the commissioner's decision for substantial evidence. And what I read your brief as saying is we're deciding whether the hearing examiner's decision was arbitrary and capricious and whether the commissioner was correct on that. And then and only then, if he's correct on that, we review his decision for substantial evidence. I mean, am I accurately seeing the different ways y'all see it, and then what's correct?
I think so, and Justice Field, I think it's really a tension between 21.303 and 21.307. And my friends on the other side, their view seems to be ignore the other statutes and just look at the commissioner's decision in 21.307. I don't think that's what the court can do.
Well, 962 of the Penal Code says use of force is justified if actors entrusted with care or supervision, I assume you don't contest that, when the actor, not the bystanders, not the student, the actor reasonably believes force necessary to further the special purpose or to maintain discipline in a group. Now, why is it unreasonable to think when you tell a student, I want your ID, it's unreasonable to just let them go? It's reasonable to let them go. You should have reasonably believed, well, he knows one of the other teacher's names, so we just let him go.
Right. So Justice Brister, I could give you the reasons that I think that it's reasonable, but I think what we start doing is going back and forth and doing closing arguments to a jury. I mean, right? I can tell you the reason that I think that it was unreasonable for him to block the door is he was provoking a confrontation when what he could have done is ask the other students or Coach B, the other teacher there, for that student's name so the student could be disciplined later.
The examiner found that was reasonable though, right?
That's right.
Your case is he should have just de-escalated.
Right. But
But that's not what this this says you're justified in using that force, period.
Exactly.
And
so,
it's kind of like, we may think, it's better not to pull a gun on somebody that, has pulled a gun on you, and you need to de-escalate the situation, but, Texas is a stand-your-ground state, and we just don't do that.
So, Justice Brister, what I would say in answering your question is going back to what the hearing examiner did in this case. What the hearing examiner looked at was once the student was on the ground, at that point, the student initially fought back and then stopped. At that point, the student posed no danger. There were other students available to help. And we know from the video that when he did get up, the student walked away. The question that has never been answered from the other side, and we've asked it at multiple points in the briefing, is under their argument, how long could he have kept the student pinned down? I mean, reasonable minds might disagree about that. Someone may think that he should have gotten up right away. Some people may think 1 minute, 5 minutes, 10 minutes, maybe the commissioner thinks 30 minutes is how long he should be pinned to the ground. But that's why we have a fact finder in these decisions.
Thank you.
I see my time is up. Justice Field, I don't think I answered your question.
I would love for you to finish.
I can
that
give
answer.
if I could just give a quick 3-point answer.
Because I'm confused. You're saying 303 requires a second step, right?
Yes. So just to very briefly your answer, and on rebuttal, I'm happy to answer further questions about it, is Justice Field, our position is there are 3 reasons that you have to, that you can't defer to the commissioner's decision with a rational basis review, but have to apply a legal sufficiency review. And that is because of context, surplusage, and absurdity. Context, because if you look at these statutes altogether, it sets up a system where the commissioner is required, and in fact the legislature said is prohibited from substituting his judgment for the board and the hearing examiner. So that's context. Second, surplusage. According to the commissioner, once you get to the trial court, you basically cross out 21.303 and say a trial court and this court never get to decide if I violated 21.303 by substituting my decision for that of the fact finder. And instead, you should uphold my decision if there's more than a scintilla of evidence in the record to support it. And I don't see how the commissioner does that without rendering 21.303 mere surplusage. And then finally, absurdity. We cited the Isleta ISD case, which talks about how going back to 1967, the good cause determination was supposed to be made at the local level and not by a bureaucrat in Austin. And so that is a long-standing history going back to 1967 in that case, and it's still in the current statutory scheme. And so it would be odd indeed for the commissioner, on the one hand, to be able to issue a decision saying, I'm reversing the lower decision because it's not supported by any evidence, and then to turn to a court and say, you should ignore what I said before, and now you should affirm my decision merely because there's some evidence in the record that supports it. And I don't see how that does that honors
Thank
the
you,
statute.
Mr. Campbell. Ms. Ortiz, Mr. Brazil, I understand you all are splitting
Yes, Your Honor.
12 and 8? You may
That is
proceed.
correct. May it please the court. This court should affirm the commissioner decision for 2 reasons. First, the decision under review by this court is that of the agency. His conclusions of law are correct, and the decision is supported by substantial evidence. Under the statutes governing agency review, specifically 21.307, which it sounds like the school district would like you to disregard, but this court should not. This court must affirm. And secondly, if the court reverses the commissioner in this case, it renders the statutes governing immunity of school employees pointless. The legislature has extended protections to governmental entities, and the statute at issue here are part and parcel of governmental immunity.
Could I stop you right before you jump in, because I wanted to follow up on Justice Field's question and make
Yes.
sure I'm understanding the parties' arguments correctly. If the commissioner finds that the hearing examiner's decision was arbitrary and capricious for failing to apply the right law, then does the commissioner get to substitute his judgment?
Yes.
And then we review that for substantial evidence, or are we still somehow in review of the examiner lands. Like,
Exactly, Your
Okay,
Honor.
good.
We are not in review of the examiner. This district would love you to go back to the examiner because that's where they won. The commissioner is the expert, of course, on his, his purview and his review. But this court, and Montgomery ISD versus Davis makes clear, it's a seminal Supreme Court case. This court is reviewing the decision of the commissioner. And this court should not reverse the commissioner unless his conclusions of law are erroneous or it is not supported by substantial evidence.
So we never look under 303 for whether he was correct that the independent hearing examiner's decision was arbitrary and capricious?
So if the court is looking at the conclusions of law under 21.307, and of course I want to allow the commissioner's attorney to respond to that as well, but our position would be that when the court is reviewing under 21.307 and it says that this court should not reverse unless the conclusions of law are erroneous, one of the conclusions of law here, for example, is that the decision or the recommendation from the independent hearing examiner, which turned into a board decision, was arbitrary and capricious, right? And so the court is looking at that conclusion of law to review whether in fact it was arbitrary and capricious. And as you noted in the other argument, Justice Ferris, here the hearing examiner completely ignores the legal standard. And I can't recall which of the justices brought up jury questions. Okay, and if this were a trial court doing this, would we allow a trial court to decide liability without first addressing the threshold issue of immunity? And that's exactly what happened here, is she completely bypassed that. She completely bypassed the legislature's edict to school districts that they cannot discipline employees for the use of justified force under Chapter 9.
Well, how would you respond to your opponent's argument that really they boil down to the same thing? It's just a reasonableness, it's just a kind of a judgment call.
And I believe one of the conclusions in the independent hearing examiner recommendation is that under FO local, this was not a reasonable use of force.
So why aren't we looking at that?
Exactly. Why aren't we looking at that? FO local is in the record. It's page 40 of the clerk's record, okay? And that's a school board policy that's set forth by school boards, and what it provides is permission to educators to use reasonable force. And it does use that word reasonable belief, I think it uses in the policy, okay? But that does not supersede, and it is certainly not the same, as you noted, Justice Ferris, as the standard in Chapter 9 of the Penal Code and Chapter 22 of the Texas Education Code, which don't provide permission to educators to use reasonable force. It provides protection for educators when they are forced to use reasonable force to control a student who is out of control, who has refused lawful directives. And so I hope that answers your question, that she sort of throws in the word reasonable a couple of times, I agree. But she tells you why she's using that word in that conclusion 6, when she says FO local does not apply here. And you look at FO local in the record, it's a board policy. She found it didn't apply here. But the commissioner has said, and as a premise of supremacy, her failure to address the statute on point, the immunity on point in favor of a school board policy does not meet her burden as an independent hearing examiner, who is trained by the TEA, who the Texas Education Code is supposed to conduct hearings as if it were a district court. Rules of evidence, Texas Rules of Civil Procedure, and burdens mean something in those processes.
But what do we do with, I mean, we've got some very, very detailed fact findings.
Yes.
Incredibly detailed. And they walk us through each stage of the interaction. How can we even say we're applying the right legal standard? How can we say that, this 2 minutes on the ground would not meet the statutory criteria for immunity, whereas, maybe if we were just dealing with good cause, then this would be good cause. Like, what is the difference?
Right, and so setting aside the issue of immunity, right, and just looking at good cause, and I don't agree that we can do that. We can't sever the immunity question out. But but let's answer that question because it came up in the district's argument, is 2 minutes. Look at page 35 of Crowley's brief. In there, they say that if you all do not reverse the commissioner here, then a teacher will be able to restrain a student for the amount of time necessary so long as that child is posing a safety and security risk. So in other words, any amount of time when that student is presenting a safety risk, restraint will be reasonable if you all do not reverse the commissioner. That's exactly the point. Whether it is 2 seconds or 2 minutes or an hour, if that student is presenting a safety risk, the teacher is reasonable in their belief that they must restrain the student. And here, in the video, you can see that the student was not calm for any amount of time before the teacher released him. You can see the principal comes up and is trying to calm the student over and over again. He keeps hitting, and he keeps hitting, and she keeps. And finally, when he does calm down, she tells the teacher to release the student, and he did. The student no longer presented a safety risk to him or to anybody else because the student was listening to the principal and thereafter went with the principal. And it's unfair for this court or for the school district, whether at the independent hearing examiner process or at the commissioner or at this court, to second guess. And he could have de-escalated. He did. You see that in the hearing examiner findings. He could have just let the student walk by. I disagree that that's an option. Unfortunately for teachers in this state, they need to be able to see ID. They need students to comply with directives.
So how do we define the special purpose? Is the special purpose compelling compliance with the command to show ID? Is the special purpose keeping the schools safe?
Exactly.
What is the special purpose that needs to be in that blank when you're analyzing the statute?
And I think that the commissioner's decision goes through this analysis, right, of this in loco parentis and the attorney general's definition of special purpose and the role of the teacher to, and not only the law, but the school district policy would require them to maintain safety. And so the special purpose here is to keep the building safe and to maintain discipline. That is not to discipline students, but to maintain discipline in the building. And that's what occurred here.
But, I mean, is there any, obviously you can't do absolutely anything, but there has to be a balance. You can't, throw somebody against the wall at the first sign of, disagreeableness. Isn't that where the hearing examiner is supposed to play an important role in this procedure? Like, isn't that why we have the examiner as the first line of review to kind of make those tough calls?
Yes, and she has to make those calls. In other words, she has to look at the statute saying that this force, if the force was justified under Chapter 9 of the Penal Code, then immunity applies, right? And she did not do that, and so for that reason alone, like without even looking past
everything she said because she didn't do that?
as arbitrary and capricious, right? The Texas Supreme Court has stated in the sources cited in our briefing that the failure to apply statutory criterion renders an agency action, and here the agency is reviewing her decision for that same standard. The failure to review statutory factors makes that decision arbitrary and capricious, and that is a specific reason in the statute on which the commissioner can base a reversal, as he did here. And I just want to leave you with this idea that what would happen? What will happen if this court reverses the commissioner? If the court does not hold school boards to their duty to apply, at least acknowledge, if not analyze, educator immunity, which the lawmakers set forth in Chapter 22 of the Texas Education Code. It is a sad fact that every day, and I don't know if you saw the news today, but even today, students are being injured in school buildings in this state by weapons carried by their fellow students. The need to restrain, to maintain safety in school buildings is more important now than ever. This court should not allow school boards to thwart and ignore their duty to at least consider educator immunity, as the school board did here.
Just a total side issue. Are Are y'all conceding on attorney's fees?
I would not concede on attorney's fees. Thank you for that question. I would not concede on attorney's fees. I believe that the affidavit does state that those were the fees expended in litigating the declaratory judgment action, which really was sort of a tag-on to the administrative appeal. But the amount of attorney's fees you can see in the record, like if the court does not agree that the affidavit is sufficient, then, that is not, I would not be surprised. I will say it that way. It's fundamental that the board must consider the threshold issue of immunity, and the commissioner correctly reversed the board decision, and his decision must be affirmed by this court. It's never been more important to Texas educators than now. Thank you.
Thank you, Ms. Ortiz. Mr. Brazel.
May it please the court. Justice Ferris, back to your first question, I think when we first started off, didn't the hearings examiner apply the wrong standard? Absolutely. The hearings examiner applied the wrong standard. The correct standard is the standard that determines whether or not the teacher was immune from this entire process. That was never considered in any way whatsoever in the hearings examiner's evaluation. Other side suggests that it was there, you just can't see it. No, it's not there, and you can't see it because it's not there. There are no citations to the statutory provisions that provide that immunity standard, 22.0512 and 9.62. There is no application of those statutory provisions. And
Well,
back,
what is, if I may interrupt
Yes.
you,
Yes.
what is the daylight between the kind of good cause standard, which includes a determination of reasonableness, and the immunity standard? Because they're in two different statutes, it would suggest that they're not the same thing, but how are they not the same?
they're not the same, and it's tough figuring out exactly why because they sound almost like the same thing.
But are they the same?
But they are not the same thing. They are completely different. And the simple answer is that one of them involves an objective observation by a non-actor. That's the standard that was applied by the district. The other one involves a determination of the reasonableness of a belief. It's not a subjective belief of that person, but it's whether or not a teacher in that position under those facts and circumstances would have a reasonable belief. Would their belief that they needed to use force, would it be reasonable? Now, they both use the terms reasonable, they're both objective, so they sound...
Use force to do what, though?
I'm sorry?
But it's use force to do what, though?
Use force, that's not spelled out. What we know is that in the context of the schools, it's use force to protect the schools and the students. We've gone through Columbine, Santa Fe, Uvalde. We've seen that in those situations, the teachers are on the front line. They're the first ones to see the warning signs that something amiss is going on. They are the first ones to be able to use force, whatever force is necessary, to try to stop it. And the whole purpose of this legislation, the correct standard, is to provide immunity to teachers when they make the choice to do that, when they put themselves on the line, as Mr. Stoneham did, put himself on the line and went ahead and acted without hesitation. When teachers do that, the legislature's decided we're going to give them immunity because we want them to do that. Ms. Ortiz is correct. If your decision reverses the commissioner, and this is one of the reasons this case is so important to the commissioner, if your decision reverses the commissioner, you will send an unbelievably powerful message to teachers that they should not get involved. Think for a minute about the videotape that you've all seen. Remember compare what Mr. Stoneham was doing to what Mr. Coach B was doing. Remember how all he did was put his hand on Mr. Stoneham's back and kind of pat him during this entire encounter. And then at some point you see him back up and do this. And even Mr. Allen, who did try to help, the other teacher, who did try to help, he tried to hold down a hand for a while, but at some point you see even Mr. Allen doing this. I'm not involved, I'm backing out. Mr. Stoneham did not back out. He stayed involved, he stayed committed. Why? Because he believed that this person was dangerous.
But we're not really here to send a message or to decide,
Right.
what school policy should be, right? We're looking at a very specific and kind of technical statute, standard of review, and we're making sure that we're following the law, right? And what it requires us to defer to, what it requires us to credit as substantial evidence.
Agreed.
So can you walk me through why we can set aside the examiner's kind of ultimate determination? It sounds like everybody agrees on what happened. Everybody agrees the initial lead up was reasonable. She finds that it's not reasonable.
Right.
Why don't we have to credit that, and why are we looking at the commissioner's
Because, I'm sorry to
decision
interrupt you.
instead for substantial evidence? So.
Because the statute authorizes the commissioner to do that, and then the statute also authorizes the court to review that decision by the commissioner. Section 21.303 authorizes the commissioner to review the record and to I hate to use these words, but this is what's in the statute, to substitute his judgment. Because of the arbitrary and because of the arbitrary and capriciousness. And just to be clear, it's arbitrary and capricious because they failed to apply a required factor. It's just from that plain old test of the 3-point test.
And so that's enough, just that one failure is enough to shake up the Etch-a-Sketch and.
Well, it wasn't just that one failure, it was the failure to apply the right law. It was about as much of a failure as you could have. It wasn't just a failure, it was the failure. But regardless, yes, if they'd still failed to apply a required standard, they would.
Well, why isn't this like the Villarreal case that's been cited?
Well, it's not like the Villarreal case for a couple of reasons. First of all, the facts in this case are very clean. Mr. Stoneham acted. Mr. Stoneham saw the warning signs. He understood them. He had his eyes open. At the moment that he recognized that things are going south here, when this individual shoved to try to get free, to get loose out into the hall. At that point, Mr. Stoneham took action, and there was no punitive action on Mr. Stoneham's part when he was holding this individual on the floor. But what's really different here is that, one of the things that's different is that in Villarreal, there was a whole line of bad facts, a history of bad acts by the individual, by the teacher. I will say that we believe that Villarreal is actually incorrectly decided because it takes the code of ethics and trumps it and puts it over the immunity statute and the immunity standard. And that's wrong. That's not intended by the legislature. The legislature has put the immunity statute in place as the primary question for this case, and then the other standards, the subordinate standards that are applied, those are used to carry out or interpret whether or not the immunity standard is correct. But they don't trump it, they don't control over it, and in Villarreal, it did control. I need to get back to be sure I cover at least this final point, and that is that the question here, it's very easy to lose the fact that the opposition here is saying this wasn't reasonable to do. The question is immunity. That's the question. Now, whether it's a preliminary factor or a factor that has to be decided first, and then you have another hearing, or whether how that's actually carried out, I'm not sure I can tell you right now. But the clear question, the clear issue, the problem is that this teacher was entitled to immunity from this, or at least a determination of whether he was immune from this process. And he never got that hearing or that consideration of his immunity, never got a ruling on it or a determination on it. And finally, back to your question that you asked, Judge Field, the statute again in section 21.307 authorizes you to make de novo rulings on errors in the conclusions of law, in the commissioner's conclusions of law. So if the commissioner erroneously decided that the hearings examiner's decision was arbitrary and capricious, you have the right to review that. I'd be glad to answer any additional questions.
Thank you, Mr. President.
Thank
you. Mr. Campbell, 5 minutes.
Would you start with the last comment on why the way they're reconciling 307 and 303 isn't correct?
Yeah, so Justice Field, I actually don't see how they're reconciling it, right? Because, you know, in the two cases the Supreme Court decided, and in many of these cases, you have a decision where the hearing examiner is affirmed by the school board, which is affirmed by the commissioner. That was the case in both Davis and in Ryu. And so in that case, it makes sense to say you would use a rational basis test because the commissioner agreed with the findings of the hearing examiner. For many administrative agencies, the agency as the adjudicative fact-finding issue, the two cases they cited, one was the Railroad Commission, one was the health, I forget. But as far as I could tell, in both of those codes, what happens is that agency does the fact-finding. Here we've got a very different situation. And so I don't see how the commissioner can reconcile, on the one hand, in the decision saying, I can't reverse the hearing examiner unless it's not supported by more than a scintilla of evidence. And then after reversing that, I don't see how he can reconcile that by just ignoring 21.303, coming to court and saying, now, don't look at what I did with what the hearing examiner did. Affirm me as long as the opposite standard. There's some evidence on the record to support what I've done. And that's what the commissioner has done. In fact, I think where the commissioner went wrong in this case is, you heard it today, I think he wanted to make a policy statement instead of just applying the law. And that's what led him down the wrong trail. If I could, let me talk about the law, and then there was one other point I wanted to make. On the law, Justice Ferris, I was thinking about your question about special purpose, and I think I understand a little bit better now, because that is referenced in the statute. In this case, I don't think there's really been any dispute that Mr. Stoneham had a special purpose in trying to get the student's ID, trying to get compliance with a directive. That is within a teacher's special purpose. But if a student doesn't give you an ID, that doesn't mean you can tackle a student in the hall and pull it from his pocket. You know, and so that was the question in this case. Sure, he's trying to do something that makes sense, that's within his purpose, but did he do it reasonably? Let me just read from the statute. I mean, the immunity statute that we're looking at looks at whether the belief is reasonable. You can't use physical force against a student if the teacher doesn't reasonably believe. And so that's the question. Was it reasonable to continue pinning the student to the ground? If I could just read, as you mentioned, Justice Ferris, this is a detailed decision with a lot of facts. Let me just read three portions of it that I think clearly show that it was not arbitrary and capricious, because it clearly considered this, which was argued to the hearing examiner, considered that standard, and made findings of fact and conclusions of law that established it. First, in finding 31, the hearing examiner said Stoneham did fail to maintain an appropriate professional educator-student relationship and boundary based on a reasonably prudent educator standard in violation of the Educator's Code of Ethics, section 3.8. Then, in the discussion section, the hearing examiner explained, again, was it reasonable? They were surrounded by other adults that were in a position to help had Stoneham release BK. Yet, Stoneham continued to restrain him for a period of time that is not reasonable. And then again, in the conclusions of law that we've talked about, conclusion of law number 8, when the two went to the ground and were surrounded by other personnel, Stoneham should have backed away. BK was no longer a danger. His conduct was inconsistent with the conduct of a person of ordinary prudence under the same or similar circumstances. The hearing examiner looked at this evidence in the light most favorable to Stoneham from his perspective and concluded in those portions and in other portions of the decision that his conduct wasn't reasonable. As the hearing examiner noted, this was not an easy case. If it had been 30 minutes, maybe it would have been easier. It was a tough call. But ultimately, the hearing examiner is the person to make that decision. Lastly, with less than a minute, we haven't discussed at all the second issue that we raised about the resignation, and so I'll largely rest on our briefing. The one thing I did want to say about that issue is that to make it clear that obviously the court does not need to reach that issue if you rule in our favor on the first issue. However, the commissioner has suggested in his brief that the issue would be moot. I don't think that's correct, because the resignation was not finalized until August. And so if you ruled against us on the first issue, there would still be 4 months of back pay that would be due to Mr. Stoneham even with the resignation that was accepted by the superintendent. So if there are no further questions from the court, we respectfully ask that the court reverse and render, or if the court believes there are any fact issues to be decided, that the court remand.
Thank you, counsel. Bailiff will adjourn the court.